a WikiVidi documentaries production. Don't forget to like and subscribe. Enjoy. Asylum in the United States. The United States recognizes the right of asylum for individuals as specified by international and federal law. A specified number of legally defined refugees who either apply for asylum from inside the U.S. or apply for refugee status from outside the U.S. are admitted annually. Refugees compose about 1/10 of the total annual immigration to the United States, though some large refugee populations are very prominent. Since World War II, more refugees have found homes in the U.S. than any other nation, and more than 2 million refugees have arrived in the U.S. since 1980. In the years 2005 through 2007, the number of asylum seekers accepted into the U.S. was about 40,000 per year. This compared with about 30,000 per year in the UK, and 25,000 in Canada. The U.S. accounted for about 10% of all asylum seeker acceptances in the OECD countries in 1998-2007. The United States is by far the most populous OECD country and receives fewer than the average number of refugees per capita. In 2010-14 it ranked 28 of 43 industrialized countries reviewed by UNHCR. Asylum has 3 basic requirements. First, an asylum applicant must establish that he or she fears persecution in their home country. Second, the applicant must prove that he or she would be persecuted on account of one of 5 protected grounds: race, religion, nationality, political opinion, or particular social group. Third, an applicant must establish that the government is either involved in the persecution or unable to control the conduct of private actors. Character of refugee inflows and resettlement. During the Cold War, and up until the mid-1990s, the majority of refugees resettled in the U.S. were people from the former Soviet Union and Southeast Asia. The most conspicuous of the latter were the refugees from Vietnam following the Vietnam War, sometimes known as boat people. Following the end of the Cold War, the largest resettled European group were refugees from the Balkans, primarily Bosnians, from Bosnia in the post-Yugoslav wars. In the 1990s/2000s, the proportion of Africans rose in the annual resettled population, as many fled various ongoing conflicts. Large metropolitan areas have been the destination of most resettlements, with 72% of all resettlements between 1983 and 2004 going to 30 locations. The historical gateways for resettled refugees have been California, the Mid-Atlantic region, the Midwest, and Northeast. In the last decades of the 20th century, Washington, D.C., Seattle, Washington, Portland, Oregon, and Atlanta, Georgia provided new gateways for resettled refugees. Particular cities are also identified. With some national groups, metropolitan Los Angeles received almost half of the resettled refugees from Iran, 20% of Iraqi refugees went to Detroit, and nearly 1/3 of refugees from the former Soviet Union were resettled in New York. Relevant law and procedures. The United States is obliged to recognize valid claims for asylum under the 1951 Convention relating to the status of refugees and its 1967 Protocol. As defined by these agreements, a refugee is a person who is outside his or her country of nationality who, owing to a fear of persecution on account of a protected ground, is unable or unwilling to avail himself of the protection of the state. Protected grounds include race, nationality, religion, political opinion and membership of a particular social group. The signatories to these agreements are further obliged not to return or refoul refugees to the place where they would face persecution. This commitment was codified and expanded with the passing of the Refugee Act of 1980 by the United States Congress. Besides reiterating the definitions of the 1951 Convention and its protocol, the Refugee Act provided for the establishment of an Office of Refugee Resettlement within the U.S. Department of Health and Human Services to help refugees begin their lives in the U.S. The structure and procedures evolved, and by 2004, federal handling of refugee affairs was led by the Bureau of Population, Refugees and Migration of the U.S. Department of State, working with the ORR at HHS. Asylum claims are mainly the responsibility of the Bureau of Citizenship and Immigration Services of the Department of Homeland Security. Refugee quotas. Each year, the President of the United States sends a proposal to the Congress for the maximum number of refugees to be admitted into the country for the upcoming fiscal year, as specified under Section 207 of the Immigration and Nationality Act. This number, known as the refugee ceiling, is the target of annual lobbying by both refugee advocates seeking to raise it and anti-immigration groups seeking to lower it. However, once proposed, the ceiling is normally accepted without substantial congressional debate. The September 11, 2001 attacks resulted in a substantial disruption to the processing of resettlement claims, with actual admissions falling to about 26,000 in fiscal year 2002. Claims were double-checked for any suspicious activity and procedures were put in place to detect any possible terrorist infiltration, though some advocates noted that, given the ease with which foreigners can otherwise legally enter the U.S., entry as a refugee is comparatively unlikely. The actual number of admitted refugees rose in subsequent years, with refugee ceiling for 2006 at 70,000. Critics note these levels are still among the lowest in 30 years. A total of 73,293 persons were admitted to the United States as refugees during 2010. The leading countries of nationality for refugee admissions were Iraq, Burma, Bhutan, Somalia, Cuba, Iran, Democratic Republic of the Congo, Eritrea, Vietnam and Ethiopia. Application for resettlement by refugees abroad. The majority of applications for resettlement to the United States are made to U.S. embassies in foreign countries and are reviewed by employees of the State Department. In these cases, refugee status has normally already been reviewed by the United Nations High Commissioner for Refugees and recognized by the host country. For these refugees, the U.S. has stated its preferred order of solutions are repatriation of refugees to their country of origin, integration of the refugees into their country of asylum, and, last, resettlement to a third country, such as the U.S., when the first two options are not viable. The United States prioritizes valid applications for resettlement into 3 levels. Priority 2 is composed of groups designated by the U.S. government as being of special concern. These are often identified by an act proposed by a congressional representative. Priority 2 groups proposed for 2008 included: Priority 3 is reserved for cases of family reunification, in which a refugee abroad is brought to the United States to be reunited with a close family member who also has refugee status. A list of nationalities eligible for Priority 3 consideration is developed annually. The proposed countries for FY 2008 were Afghanistan, Burma, Burundi, Colombia, Congo, Cuba, Democratic People's Republic of Korea, Democratic Republic of the Congo, Eritrea, Ethiopia, Haiti, Iran, Iraq, Rwanda, Somalia, Sudan, and Uzbekistan. Individual application. The minority of applications that are made by individuals who have already entered the U.S. are judged on whether they meet the U.S. definition of refugee, and on various other statutory criteria. There are 2 ways to apply for asylum while in the United States. If an applicant is eligible for asylum, they have a procedural right to have the Attorney General make a discretionary determination as to whether the applicant should be admitted into the United States as an asylee. An applicant is also entitled to mandatory withholding of removal if the applicant can prove that her life or freedom would be threatened upon return to her country of origin. The dispute in asylum case is litigated before the Executive Office for Immigration Review and, subsequently, the federal court centers on whether the immigration courts properly rejected the applicant's claim that she is eligible for asylum or other relief. The applicant has the burden of proving that he is eligible for asylum. To satisfy this burden, an applicant must show that she has a well-founded fear of persecution in her home country on account of either race, religion, nationality, political opinion, or membership in a particular social group. The applicant can demonstrate her well-founded fear by demonstrating that she has a subjective fear of future persecution in her home country that is objectively reasonable. An applicant's claim for asylum is stronger where she can show past persecution, in which case she will receive a presumption that she has a well-founded fear of persecution in her home country. The government can rebut this presumption by demonstrating either that the applicant can relocate to another area within her home country in order to avoid persecution, or that conditions in the applicant's home country have changed such that the applicant's fear of persecution there is no longer objectively reasonable. Technically, an asylum applicant who has suffered past persecution meets the statutory criteria to receive a grant of asylum even if the applicant does not fear future persecution. In practice, adjudicators will typically deny asylum status in the exercise of discretion in such cases, except where the past persecution was so severe as to warrant a humanitarian grant of asylum, or where the applicant would face other serious harm if returned to his or her country of origin. In addition, applicants who, according to the U.S. government, participated in the persecution of others are not eligible for asylum. A person may face persecution in his or her home country because of race, nationality, religion, ethnicity, or social group, and yet not be eligible for asylum because of certain bars defined by law. The most frequent bar is the 1-year filing deadline. If an application is not submitted within 1 year following the applicant's arrival in the United States, the applicant is barred from obtaining asylum unless certain exceptions apply. However, the applicant can be eligible for other forms of relief such as withholding of removal, which is a less favorable type of relief than asylum, because it does not lead to a green card or citizenship. The deadline for submitting the application is not the only restriction that bars one from obtaining asylum. If an applicant persecuted others, committed a serious crime, or represents a risk to U.S. security, he or she will be barred from receiving asylum as well. In 1986, an immigration judge agreed not to send Fidel Armando Alfonso back to Cuba, based on his membership in a particular social group who were persecuted and feared further persecution by the government of Cuba. The Board of Immigration Appeals upheld the decision in 1990, and in 1994, then Attorney General Janet Reno ordered this decision to be a legal precedent binding on immigration judges and the Asylum Office, and established sexual orientation as a grounds for asylum. However, in 2002 the Board of Immigration Appeals suggested in an ambiguous and internally inconsistent decision that the protected characteristic and social visibility tests may represent dual requirements in all social group cases. The requirement for social visibility means that the government of a country from which the person seeking asylum is fleeing must recognize their social group, and that LGBT people who hide their sexual orientation, for example out of fear of persecution, may not be eligible for asylum under this mandate. In 1996, Fozia Kasinga, a 19-year-old woman from the Chamber Kunsanta people of Togo, became the first person to be granted asylum in the United States to escape female genital mutilation. In August 2014, the Board of Immigration Appeals, the United States' highest immigration court, found, for the first time, that women who are victims of severe domestic violence in their home countries can be eligible for asylum in the United States. However, that ruling was in the case of a woman from Guatemala and was anticipated to only apply to women from there. On June 11, 2018, Attorney General Jeff Sessions reversed that precedent and announced that victims of domestic abuse or gang violence will no longer qualify for asylum. Brought to you by WikiVidi Documentaries. Would you like to know more?